Good morning. This is Judge Elisa Bettis presiding over the 210th District Court Civil Docket for March 20th, 2024. All matters being heard today are being heard in accordance with all directives regarding remote proceedings. In addition to that, we are streaming all matters live via YouTube for public viewing. Mr. Monares, would you call our first case, please?
Calling cause number 2022 DCV 2483, Matthew Thomas Bell versus Brian Misael Arellano and Root Insurance Company. May I have announcements, please?
Good morning, Your Honor. Manny Morgan on behalf of Mr. Bell.
Good morning, Troy Brown on behalf of the defendant, Mr. Arellano.
Good morning, gentlemen. We are here on an entry of judgment. How are we doing? I don't recall receiving any documents.
We're still awaiting funds. I spoke with Mr. Brown. He anticipates to have them here soon, and once we have those, we'll follow all the dismissal work, Your Honor.
What are we talking about soon? 2 weeks?
I'd ask Mr. Brown.
Mr. Brown.
Judge, my client is actually one of the few that's extremely responsive, and I spoke to him this morning. He said he could have me the check this week. So I've sent over the release to Mr. Morgan.
I'm saying 2 weeks. Where does that put us? 2 weeks sounds good. I wanted to make sure we weren't conflicting with any holidays. Yeah, we'll do 2 weeks.
Thank you, Your Honor.
Thank you, gentlemen.
Thank you so much.
Have a good day.
You too.
Thank you.
All right, who's next?
Same page, Judge, 4842, next one below.
Is everyone here?
Yes, Your Honor.
Go ahead.
Calling cause number 2019 DCV 4842, Maria del Carmen Lopez versus David Antonio Burciaga Monroy et al. Can I have announcements, please?
Good morning, Your Honor. Tomas Porras Acosta on behalf of plaintiff Maria del Carmen Lopez.
Morning, Your Honor. Michael Hirsch on behalf of the defendants.
Good morning, gentlemen. Another entry of judgment. How are we doing?
So this is going to be the reoccurring one, okay? But we have good news somewhat. We went ahead and we were able to get in contact with the clients. We informed the previous judge that we needed to change the affidavit into a verification because of my client's distance in Mexico. So we finally did that. I got the documents back last night in anticipation for this hearing, but she signed everything except on the verification where it says executed on state, county, country. So she signed the verification, but she just didn't sign that part. And so everything else is executed. All I need to do is I've been trying to get in contact with her, but there's a time difference. And so all I just need to do is get that signature, and this case is over, Your Honor.
Okay, so we'll do a 2-week reset as well. That's, I think, April 3rd. That puts us at April 3rd.
Thank you, Your Honor. Appreciate it.
Have a good day, guys.
Thank you, Judge. You would be excused.
Yes, sir.
Thank you, Your Honor. I have another case later on, but I'll just stay on the if that's okay.
That's fine. Thank you. All right, was the expunction taken care of?
Yes, it was, Judge.
Okay. All right, next.
Next one, page 2, 3302, second one on the page. Calling cause number 2022 DCV 3302, Jacob Cavender versus Abraham Gamboa. Can I have announcements, please?
Good morning, Your Honor. John Alfier from the law firm on behalf of the plaintiff.
And Joshua Murphy on behalf of defendant Gamboa, Your Honor.
Okay, the motion for continuance, I did not check my emails. Is this was filed on February 28th. What are we looking at? We're looking at like a full-on reset for how long, or what are we asking for continuance?
And part of that, Judge, is we're trying to obtain some imaging records. I don't know how long that'll take. I'm hoping within 3 months, Judge, but I couldn't give you a certainty as to that. That's been the main reason for the continuance, getting those imaging records that we've been attempting to get.
Okay. All right. You know, we've got a little bit of a window, but it's not 3 months. What do you all anticipate? I mean, if we went past this trial setting, what are you all asking for?
Judge, I don't have my client's consent to even agree to the continuance. I'm not opposing it, so he will be very upset about any delay. So as soon as possible is my position.
You know, kind of with that understanding, Mr. Murphy, I'm not saying, you know, I probably asked for this to be set today, but we still have a final civil pretrial. So I'm just going to take the motion for continuance under advisement at this time. I will see you at the final civil pretrial. It's only about a month away. If we have an update, I also wouldn't mind going all the way up to the docket call. But let me ask, have you all mediated?
April 15th, Your Honor.
Hijola, right at the deadline. So that makes me think I will wait all the way through that date to review the continuance. So I'm going to just take it under advisement for now, Mr. Murphy, and see how we go. We'll see you at the next setting. Is there anything else you all have for the court?
No, Your Honor.
Thank
Nothing
you very
further,
much.
Judge.
You all are excused if you don't. I think, Mr. Murphy, you have something else.
Yes, Judge.
All right, who's next?
Page 2 for Mr. Lopez Enrique.
Okay.
Calling cause number 2022 DCV 3622, Mary Gonzalez versus Juvencio Pacheco and Rebecca Pacheco. Can I have announcements, please?
Good morning, Enrique Lopez on behalf of defendants and also counter petitioners now.
Okay, let me ask, is there anyone in the waiting room? Mr. Lopez, have you had any contact with Ms. Gonzalez?
No, Your Honor. In fact, last time we had, there was a visiting judge and she did not show up either. So I did file a motion to dismiss her claims. And I'll be filing a motion for summary judgment on our counter petition. This is the case where
I remember the case of
Remember
Mr. Yes, I do, Mr. Lopez. So I'm just looking at the calendar for now. I see the motion to dismiss was filed. It wasn't set. I would like to have everything set together. Our next setting is April 24th. If you get your summary judgment filed with enough time to have it heard that day, we can schedule it that day. If not, we'll have to look outside of those dates for a hearing date, okay? And
Okay.
that'll be on both, okay?
Thank you, Your Honor.
Thank you very
Happy
much.
to.
You may. And just so I'm clear, Myrna, Mr. Monares, we didn't receive any contacts from Mary Gonzalez.
No, not on my end, Judge.
Thank you. Okay. All right, who's next?
Same page, page 2, 2141. Calling cause number 2022 DCV 2141, Hector Medrano and Rocio de la Fuente versus Marion Shields and Coke et al. Can I have announcements, please?
Yes, good morning, Your Honor. This is Cindy Vasquez, Mitch Moss, and Greg Suquet on behalf of the plaintiffs.
Morning.
Greetings, Your Honor. Amado Montoya on behalf of defendants.
Okay, and I believe I have a motion for continuance here as well. My apologies. Whose motion is it, or is it a joint motion?
Yeah, Judge, I believe that's our motion. Mitch Moss here, Your Honor.
Okay, there you are. Sorry.
Hi. So as you know, Cindy and I just jumped in. Mr. Herring was in this. He withdrew, and so we jumped in to assist co-counsel here, Mr. Soquet. I know we're set for trial, and in the motion, you'll see the problem I have, and it's my fault. I am scheduled to speak for Defense Counsel Association in Key West with the family on the 24th or 25th. And I'm torn on this case because we tried to mediate within the last week and got nowhere. And one of our clients told me he's down to $700. He's about to be homeless. He doesn't know, and so trying to push this off is really a disservice. And so we had asked Mr. Rincon and Mr. Montoya if we could try to find a date in a couple of months so this wouldn't drag out too long. And apparently Mr. Rincon cannot do that. He's got other settings, which I think we all do. And so I didn't know if Mr. Montoya was going to try this case or if it was going to be Mr. Rincon. But the only other option, Your Honor, is if this is going to get pushed off until next year, it's going to kill our clients. And so I don't know if the court would indulge in a request to start the trial on Monday instead of Friday, so I could, I'd be back on the weekend, and then I could pick the jury on Monday and instead of Friday, if that's even a possibility in your world. I just thought I would ask.
All right, Mr. Montoya, I see there's a response in opposition, so.
Yes, Your Honor, the only thing regarding the proposed jury settings for July and August is just not workable for us. Yeah, me and Ms. Bracon are working on these many of these trials together, and so those dates just won't work. And we were looking at our trial calendar, and it looks like our only availability is looking to be in either December, January, February of next year.
Well, I mean, it's going to be pretty difficult in terms of, I wouldn't have a jury panel. Let me see if we're talking about 24th to 26th. I wouldn't have a panel for the 29th. Let me check something really quick. The other thing that pops into my head, but I don't know that it would work. How can I say? I can't assume. If I were to refer you all to one of the referral judges, either Judge Baril or Judge Alcala, I don't know that it makes it any better. I usually do that when scheduling is really difficult for the court, because we are beyond full. And so let me just look at something. What I could do, possibly, but it requires quite a bit of work and trying to find, I have tried to go double, right? So I bring in a visiting judge, we get an extra bailiff, an extra court reporter, which is not an easy task. Let me see what we have.
Judge, I'm so sorry to be such trouble. Are we the number one setting on the 26th or whenever that Friday is?
No, you're not. You're not. But if you all are telling me that you could start it on Monday, is that what I thought that's what I heard. We could start April 29th with jury selection. Is that what you're telling me?
Correct, Your Honor.
Okay, let me look at the calendar here.
And Your Honor, that may not work for us, Your Honor. We have a trial on, believe it's May 4th.
That's a Saturday. So if you're doing that, that's off to you.
I didn't mean, yes.
I'm just kidding. I know calendars are funky.
Yes, May 3rd.
How long are you all, hello, Mr. Rincon. How long are you anticipating this trial is going to take?
4 days, 3 or 4 days now.
Mm-hmm.
Did y'all file a motion for continuance?
They opposed ours.
Yeah, we just filed a response notifying that we had conflicts with the proposed July and August dates, and that was the response to the continuance.
So there's no objection to the current trial setting?
No, we can go to trial as set.
You can go to trial as set, except Mr. Moss is unavailable. We're 1 day off there. And Mr. Moss, if I were to grant a continuance, I assure you it would be January 2025.
Yeah, Your Honor, and in all fairness to Mr. Moss is new to the case, and we understand that. It's just that the dates that were being proposed for new trials conflict with other settings. At a January 2025 setting, I think would work. In my view, we suggested January, February. That would work for us if the court's inclined to grant it.
Certainly, and that, Mr. Rincon, I don't know if you're on. One of our clients is, almost out of money and doesn't know what he's going to do. I mean, it's pretty bad to go in and tell him that because of me, this is going to get put off to January. I just don't know if I can sleep with myself or live with myself. So that's why if the judge can work some magic and we could start of the first of the week, I would be grateful and get this one out of the way and get it off the list.
Mr. Moss, realistically, I think it's very difficult. I know I'm throwing that out there, but it's really difficult. I tried to do it in February where I had an overlapping special settings, you know, criminal murder, and then a civil case that was for sure had to go. And it really was difficult. The only space that was available in this building was next door in an associate court. And I know the attorneys weren't real psyched about picking a jury in there. And I didn't blame them, you know, luckily we averted it, but it was quite difficult to do.
Judge Alcala an option, or I know he's busy too.
Well, I could do that. I mean, that's why I'm saying I could refer this to either Judge Alcala or Judge Burrill. If turnaround time, I mean, they would have more flexibility, right? They would have a lot more flexibility in terms of a trial calendar that might work with your calendar, because I can tell you we're as busy as you are, right? And so the all of us getting together really does mean 2025 if you're staying here. I'm happy to refer you to either of the referral courts and see what you can do with scheduling to see if that helps schedule.
The only problem is that's not changed Mr. Rincone's calendar. He's telling me he doesn't need any trial settings between now and the end of the year. And so I'm in the same boat. So what if I guess maybe I don't pick the jury when we start on the 29th, I just show up on Monday. You know, I mean, I just feel like I'm really doing a disservice to these people, and I'm struggling, Judge.
Okay, well, I am going to refer you all then to Judge. I really, it doesn't, to me, it's whoever's more available, Judge Burrill or Judge Alcala, unless I hear anything from you all.
Your Honor,
Monday.
if I may, I haven't had a case transfer scenario in some time. But sometimes, and I I have to consult with the clients. They're familiar with Your Honor and know that you're assigned this case. So when I announced to them that we're going to have the case transferred to a judge, almost instinctively, what these clients will ask is whether, and I do not know Judge Alcala. I know Judge Burrill because I've known her forever. And I don't know to what extent they're going to ask me, well, in my opinion, but ultimately it'd be their decision if they want me to voice some kind of objection. And I don't say that in any form of disrespect to an assignment. So I think I recall the rules working is I can object once, but then the second time, provided it's to a sitting judge, there is an objection, but to a like a retired judge, I may have a perpetual objection. And again, I'm not trying to be difficult, but that's the issue. I mean, I know we were set for trial when we were set in April, and then we had this anomaly with the original lead counsel. And so it's just, if the other dates that were being proposed worked, we wouldn't have any problem trying the case. And Mr. Moss and I just tried a case, so they know we're trying cases. But it's just that there are so many cases that are backlogged, and every one of them is everybody wants to get to trial. It's a kind of a life and death thing. I get that, but
Mr.
if we don't go,
are you telling me that there was a proposed date that you all had agreed to?
No.
Okay.
When Mr. Moss entered an appearance, as I understand it, and if I'm misremembering, I can be corrected, but they proposed new dates, and those dates didn't work on our calendar. So that's when we said, well, January, February 2025. And for the court's edification, we're getting dates for our experts, and we just finished taking plaintiffs' experts, and we're looking to file a fairly large Dalbert motion to 5 of their experts. That's getting filed today. or tomorrow. But there's a little bit of work to do still yet, and just FYI.
Okay, well, I don't know that, the more I'm looking at this, the more I see that, I don't think there's going to be a realistic accommodation for the April trial setting. So let's get the ball rolling. We're going to refer to Judge Alcala. So Myrna, if you will prepare the referral order. So it's a referral. It still stays in the 210th. It's just he's the presiding. And Myrna, I am going to ask that you get in touch with the court coordinator for the referral courts to set this for an ASAP status conference. Do we know who is the court coordinator for the referral court?
Jackie Caudillo, ma'am.
Okay. Do we have contact information for the referral court coordinator?
Yes, ma'am.
If you would provide that to the attorneys. And that's what we're going to do. We'll send it that route. Mr. Rincon, I understand if you do have an objection, whatever, that'll come back here. We'll get it said. Let us know. Okay.
Okay, Judge.
Okay. All
Judge,
right.
the coordinator's name again is Jacqueline Caudillo.
Can you put it in the chat?
Sure.
To everyone, please. Yeah. You know, I'm almost kind of the opinion of, you know, taking a stab at either referral court, either judge. And I don't know, I feel like I've probably referred more to Judge Alcala, so I don't know how much busier his schedule is than Judge Burrill. But we'll start there. We'll start there. I could tell you, you know, if you all would be inclined to go back and look at your schedules, I feel like May is turning out to be much more workable than it was going to be. So if you could find some time thereabouts, but that's only a month, you know, after.
No,
But if it helps your schedules, I will definitely work with you on that.
Your Honor, do you have, and that's good suggestion. Do you have weeks that you know you're available in May?
So May, you know, Mr. Rincon, really don't hold me to this because I don't have my full trial dockets, but I know I'm not heavy on special settings. I only had one civil case that was specially set that was supposed to last 3 weeks, and that is gone. So let me see, let me look at the calendar if I can find the right year here. You know, we're probably looking at May 17, 24, 31, but that is without me looking at my criminal docket. And you're saying how many days? About 4 days?
Yes, Your Honor.
Yeah, 4 or 5 days, somewhere in there. Move it along pretty quick.
Let me look at something real quick. Calendar, May. I have to check jury panels, things like that. You know, Myrna, do you see anything in terms of trials on May 2nd? Do you see anything special? Let me go to the calendar.
There are no special settings, Judge, but I'm looking at May 3rd, which is Friday. So May 2nd?
But we have a commissioner's court on May 2nd. That's why I'm wondering if we had a specially set case. Because that would also bump us up a little bit. See why we had a large panel coming in on the 2nd. That also might be a case that went away. Is this right? Look, if we're trying to be really flexible and trying to work things, I don't see any trials, Myrna, on May 2nd.
There are
No,
none
no.
set.
I have a trial that is set in Judge Garcia's court in the 384th, but it's a case that I inherited from the Mounts Green Myers firm. It's set for trial. I need to check with counsel, plaintiff's counsel, to see if he's actually ready to go. But here's another thing. The week of May the 17th, it looks like you all do jury selection on Friday, May 17th. And I think that looks to be a workable date, and then the following week for a trial. I don't know if that works for Your Honor.
So for the 16th and the 17th, I actually have panels on both those days. So if you all wanted to start on Thursday.
Let's see, Thursday.
Why don't you all go back and check your schedules for those days and
Judge,
email?
yeah, I think the Friday, the 17th would work with the week following for a trial. I think we can make that work.
So give me a second.
Cindy, will that work for us or?
I'm looking, we do have a case set for trial. It's a 2019 matter in Judge Cardone's court beginning May 31st, and that one's gonna go for a while, at least a week and a half.
Okay, well, if we did the 16th or 17th, we should be okay for that one then. Yeah, I could start on the May 16th.
Yeah, I think.
Why don't we do this? Before I send that order, if you can get back to me by end of this week with confirmation with all of you all. And I will ask you to think of starting on a Thursday, Friday, Thursday and starting evidence, okay, on Friday if we pick a jury on Thursday, because to the extent that the length of your trial will impact like my murder that is set the next week, you know, I'd like to get you all started sooner than later.
Sure, Judge, that sounds great.
That'd
Okay.
work for us. Carlos, do you want to check on your end, make it work?
Yeah, I will. I get back to you pronto.
We'd appreciate that. And that'd give us a couple of weeks to knock out a few other depots if we needed to.
Okay. Okay. Out of an abundance of caution, I am going to reset the motion for continuance of today's status or whatever we had today for 1 week.
Okay.
All right. Solved because we've taken your suggestions and run it against our calendar and we're all good. I will cancel that hearing. Okay.
Man, that would be great. Make this work. I'd appreciate it, guys. Thank you.
No, thank you very much.
Thank you.
That sounds
Thank
fair.
you. Everyone, was there anything else? No.
No, I have another hearing, I think, right now.
Okay. Okay. Then Myrna, let's hold off on that referral just for now. Okay. All right. Okay, let's go to the next one. What's next?
Thank you very much.
Thank you.
Next one is on page 2, Your Honor, 3342. Calling cause number 2022 DCV 3342. Miriam Rivas and Edward Rivas versus El Paso County, Texas, and Lorenzo Javier Juarez. Can I have announcements, please?
Good morning. Jonathan Baeza on behalf of Ms. Labinati for the plaintiff.
Kurt Paxton for the County of El Paso.
All right. Oh, my little notation says did not settle. I don't know if that's an old notation. I might be late to the game here.
That is correct.
Final status.
That's correct. It did not settle, and I believe we are ready for trial, Judge.
Oh, don't tell me it's April 26th.
It is April 17th. Or sorry, May 17th. I apologize. The one you.
So I was giving away your trial date, and you didn't go like this, Mr. Pesta. Whoa, Judge. That's my trial date.
I was a little concerned.
Okay. All right. Well, Myrna, there's number one problem. We already have some stuff. Yeah, I can't absorb mentally everything on the docket in such a short period of time for scheduling purposes. All right, well, we still have a final civil pretrial coming on April 17th. What else is outstanding? I see jury questions. I see a plea to the jurisdiction, some of the recent filings. Anything need to be said for a hearing?
Judge, we'll try and get it cleaned up. They've requested exemplary damages, which are not allowed against a governmental entity like the County of El Paso. They've also requested $1 million. The statutory cap is $100,000. We'll have a plea to the jurisdiction as to any amount above the statutory cap. Those are minor housekeeping matters. This is a case that does need to be tried.
Okay, well, thank you, Myrna. Please put that on that trial docket. Okay. Well, let me just say this. Outside of the hearings that we have, if you need additional hearings, I don't want to wait until, May 15th or 14th to start scheduling things. So if you need hearings on anything that is outstanding or you're in agreement to have something ruled on by submission, let me know, at least by the final civil pretrial, okay?
Very fine, Judge.
All right, anything else?
Nothing.
Y'all are excused. Thank you very much.
Thank
I've
you.
got one more. I'm going to hang on, Judge.
Okay. Who's next, Mr. Monares?
I'm not sure if all the parties are here for 3049 on page 1. Is anybody here waiting for case number?
2022 DCV 3049.
Is that the Cabral case?
No, sir, it's Aurora and Gilbert Alba versus Allstate Texas Lloyds.
Not
Hi, Judge Sebastian Nunez here on behalf of all states.
And who is here on behalf of plaintiff? Mr. Medina, can you look up and see who received notice and if they opened it?
Yes, Judge, I'm on it.
Thank you. All right, let me get there. Mr. Nunez, who have you been dealing with plaintiff's side?
Douglas Baker and Eric Quiroz, Judge.
Okay, so it looks like there is an agreed motion for continuance of the jury trial setting, but that was not, it's not set for today. I wouldn't mind hearing it if, let me see your motion, just additional time if we had counsel for plaintiff here.
Judge, I think the basis is that mediation is scheduled for, let me make sure, Judge, it's. So mediation is scheduled for May 6th of 2024.
Okay, so I'm gonna leave that agreed motion outstanding. Myrna, we're gonna put the final civil pretrial. You said May 6th, Mr. Nunez?
May 6th, Judge.
Okay, we're gonna do May 8th. That final civil pretrial will be May 8th. Okay?
No problem. Thank you,
We'll do
Judge.
that for now. Okay. Mr. Medina, were you able to see anything?
Yes, Judge. What I'm seeing is the only people that opened it was an Eric Quiroz, Kim Laurie, and Rick Loya. The rest of them that says not opened.
Okay, so we'll make a notation that plaintiff's counsel failed to appear. Thank you. All right, who's next?
Is anybody here on 2022 DCV 3387?
Paul Stockton on behalf of the plaintiff.
Mr. Grambling here?
No, ma'am.
Okay, so is there another one that's ready?
Yes. Calling cause number 2022 DCV 0886 Eduardo Cabral, individually and as here at law of the estate et al. Can I have announcements, please?
Good morning, Your Honor. Good morning, Your Honor. It's Brendan Villanueva on behalf of the plaintiffs.
Good morning.
Your Honor, Carlos Rincon here on behalf of Landstar Ranger, the movement on today's motion.
Morning, Judge Sebastian Nunez here on behalf of defendant RV Share.
Paxson,
Kathy.
Good morning, Your Honor. This is Dan Hernandez on behalf of my universe.
I'm sorry, I missed the one before that. Was that Mr. Cathy?
It was, I think.
Yes, Your Honor. Mr. Cathy, Brian Cathy on behalf of Landstar.
Yeah, he's my appellate counsel on this case, Your Honor.
Good catch, Eric. I didn't even hear that one. I thought you were talking about Mr. Paxson. Okay. And then let me see. Now I lost count. Is that everyone? Okay. So motion for continuance. Is that the only thing we have? Motion for
Yes, Your
continuance. All right, Mr. Rincon.
Your Honor, this is a multi-party case with 5 or 6 esteemed counsel, less myself, involved in either prosecuting or defending claims. There are 4 co-defendants, and the process of scheduling and taking depositions has been laborious. The lawyers have worked very well together, and we're continuing through. So in the course of things, we are still very deep in fact discovery. We're just now still trying to complete the fact depositions of the parties themselves. And we're scheduled to be deposing the corporate representative for Expeditors, a co-defendant who's a freight forwarder, at the very end of this month. And also what we think could be a very key material fact witness at the latter part of April, who also works for Expeditors. And there's other parties who haven't even been able to schedule their corporate rep depositions yet. So what occurred was Expeditors had previously filed a motion for summary judgment, and we respectfully requested, and they were gracious in agreeing to pull down a hearing on a motion for summary judgment pending our ability to do basic fact discovery against Expeditors, because it is our position that factual assertions that Expeditors is relying upon in its motion for summary judgment against the plaintiff's claims against it are disputed. And we intend to dispute them, even though we are not the plaintiff, but we have standing to do so. But the point of this motion, Your Honor, is this. For us to be able to develop the summary judgment evidence that we intend to attach to our motion for summary judgment response, we need the transcripts and we need the depositions of the corporate rep for Expeditors and the material fact witness at the end of April. I had requested if we could come to some accord to simply push the hearing on Expeditors' motion for summary judgment until sometime in, say, mid-May, to give us a chance to get the transcripts, digest them, and formulate our response. And I hadn't heard back from counsel, and I know everybody's busy. I think that the request for an adjournment of the current summary judgment hearing on Expeditors' motion for summary judgment would serve the interests of justice. It would not cause prejudice because, as noted, we are still in the thick of the fact discovery, and this case is not set for trial until November. We're not asking for a long adjournment, but we need this evidence because we need to file a response. Now, I don't know if my motion for continuance even drew an opposition. We've not heard a verbal opposition, just no response. And I don't believe we've received a written opposition. We think it's a meritorious, reasoned request. We're all working very hard. But for the record, I attach for your court's consideration the emails and the deposition information to chronologically demonstrate the due diligence that Landstar Ranger has been pursuing, the depositions that are being complete, and the fact that we've been trying to coordinate these depositions for some time. One of the witnesses is a Spanish-speaking only Mexican national who has a very busy schedule, and he's not available till late April. And the corporate representative is not available till late March. And again, through no fault of counsel or the parties, just people being busy, and certainly through no fault of Landstar Rangers, has been the result of dilatory or lack of effort, due diligence, none of that. Everybody's been working very hard. So we're simply asking that the hearing set for early April be adjourned and reset for sometime in mid-May. That would be fair, we believe, and we respectfully submit an order of adjournment, and that this matter just simply be reset to about 6 weeks after it's currently set. So that's the requested relief.
All right, I do not see a response on the motion for continuance, and my question was turnaround time. So you're saying mid-May. Maybe we can do it during your trial, Mr. Rincon, on the other.
That would be killing two birds with one stone, Your Honor. We'd gladly do that. Take a short break.
No, that's too much for me.
Judge,
Let
can
me
I
get a
respond though?
Absolutely. No, yes. Mhm.
Judge, I represent expediters, and we filed the motion for summary judgment. We're characterized by Mr. Rincon as a freight forwarder. We have a service provider agreement with his client, Landstar. Now, pursuant to that agreement, our people look to Landstar as the carrier. If something goes wrong with this load, they look to Landstar. In fact, Landstar does broker the load to My Universe. And as between Landstar and My Universe, there's no doubt My Universe is the tractor and the trailer and the driver that's involved in this accident. And so, again, we've got one agreement where we have one relationship, but there's a separate relationship between the two of them, and it's characterization or using the same words, okay? Maybe the French have better words to describe these relationships than English does, but we're using the same words, but we have a different relationship. He's very sensitive to the fact that we're calling his client the carrier, and he takes issue with certain factual assertions that it represents the testimony of my client, that represents the service provider agreement that his client signed. But at some point in time, the train needs to pull out of the station. We are entitled to summary judgment in this mess. And I do not believe, and I'd like to see some case law, that a co-defendant has standing to oppose another co-defendant's motion for summary judgment. I'm not moving for summary judgment as to him. He has no claim against us, nor can he. I'm moving for summary judgment as the plaintiff's claims. And the plaintiff is the one moving for continuance here. So I work well with Mr. Rincon. He's very professional. I know he wants to take these additional depositions. I'm willing to work with him to make that happen. But I'm saying at some point in time, Judge, we do need this summary judgment heard and considered. And I just wanted to preview the legal issue.
Understood.
Your Honor, a short response.
Yes, sir.
The characterization of Landstar Ranger as a motor carrier in this freight sequence is incorrect, as was just expressed, in our opinion. And words do matter, the agreements do matter. That's why we need the depositions, because in our view, what we don't want is for the court to adjudicate the motion for summary judgment without the benefit of my client having at least the opportunity, 14th Amendment due process, to point out this discrepancy or dispute on a fundamental assertion being made the basis for summary judgment relief. Because what happens, and I've seen it in other cases, parties will insist that depending on how the court rules, it could serve as a collateral estoppel, like a bar to raising a defense, and we're not going to get there without having the opportunity to build a record and make argument. The second thing is we take, Mr. Paxton's a longtime friend and colleague, we do take exception with the assertion that a co-defendant in a civil matter does not have standing to file an opposition to a summary judgment filed as to another party's causes of action against it. The law will allow us, for the reason I just expressed, claim estoppel, defense estoppel, to file evidence so that the court has before the record that if in fact there's a dispute on a factual assertion or a legal characterization assertion in the record, that's fair game for the court's consideration of a summary judgment if that's a material basis for the relief requested. But that's not on the table today. That would potentially be an argument to be made at summary judgment time. And we do plan to brief that. We have our appellate counsel here available to address that, but that's not an issue today. Today is simply the motion for continuance. We think it's merited. And just like to use Mr. Paxton's phrase, the train will leave the station relative to the hearing on the summary judgment. We're just simply asking that it not leave Penn Station till mid-May and that the hearing be held. We're not asking for an unreasonable amount of time, just enough to finish these 2 depots, get the transcripts and work them in.
We're not opposed to that. We're not opposed to that. But Judge, we are going to join issue on whether or not a co-defendant. I've never seen it, and I'm curious to see what a case law or what they could provide on that point, and we'll join issue at that moment.
Yeah.
Your Honor, if I may.
Yes, sir, Mr. Villanueva.
All right. Thank you. I represent the plaintiffs in this matter, and it's a little odd. I do agree with Mr. Racone in some circumstances. I do agree with Mr. Paxton in some circumstances. I agree with Mr. Paxton's characterization of Landstar, but I do agree with Mr. Racone in that it would make sense, since we already have 2 depositions set, and they've been set for quite a while. Nobody's quashed within the 3 days, and I don't think anybody's has a conflict. So those depositions are going to occur. The corporate rep on March 26th, and then Adrian Maciel, who is the main person that I've seen that is coordinating the shipment of the load that is involved in this incident. And that's set for April 19th. So, Your Honor, it would just make sense that we have these transcripts for the summary judgment hearing. We wouldn't want the hearing to be tainted because we didn't have a certain transcript, and then someone could later appeal that, this discovery was pending and we didn't have it. We'd like to have, if whatever the court rules on Mr. Paxton.
Nobody's opposing it. Nobody's opposing it, Judge.
Mr. Villanueva, you can finish, please.
Yeah, we just want to make sure that whatever happens at the hearing, we have all the information, so that way, there's not any collateral appeals or contests to what is ultimately decided. And, having a deposition looming a couple of weeks later could give grounds to that. So I think it would make sense that we do it at least a month from Mr. Maciel's deposition, so we give court reporter some time to get us the transcripts. It would give Mr. Paxton and his witness some time to, write on the errata sheet and all that stuff. And so we can look at it.
I already looked at May 8th, just looking at the court's calendar, and that sounds like that's going to be a little earlier. Are you asking for something later than that?
Oh, middle part of May, Your Honor. Somewhere in that time frame.
All right, for now, I'm going to say May 15th, but I'm going to ask Ms. Hernandez to, so your request for continuance is granted, it's unopposed. May 15th, I'm going to say 10 a.m., but that's just pending Ms. Hernandez verifying that we're not going to be out of pocket. So at most, I will put you at the earliest, May 15th, maybe a week, maybe 2 weeks later than that, depending on the court's calendar. Okay?
Very fine,
Yes,
Judge.
Your Honor.
Thank you, Your Honor.
Is there anything else for today?
No, may we be excused, Your Honor?
If there's nothing else, you are all excused.
Do you want me to circulate an order granting the motion?
Yes, please, and just leave the date. Well, yeah, don't put a reset date in there. Just say granted.
Okay.
Thank
All
you.
right, good. Thank
Thanks
you. Have
very
a
much.
glorious afternoon. Bye-bye.
Same to
Thank
you
you,
all.
everybody.
Good
Bye-bye.
to see everyone. Take care. I saw Mr. Grambling and Mr. Savinov.
Hi, Your Honor.
Howdy. Okay. Man, I keep messing with the Odyssey calendar. I'm never on the date I need. All right. Go ahead and call it, Mr. Monanes.
Calling cause number 2022 DCV 3387, Jennifer Ramos versus Sarah Nicole Arispe. Can I have announcements, please?
Paul Savinov for the plaintiff.
Randy Grambling on behalf of the defendant, Your Honor.
And we are set for final status conference. How are we doing?
Judge, Mr. Randy and myself, we've communicated earlier. We have agreed to mediate the case. We're just confirming.
Let me see. Sorry, go ahead, Mr. Savinov. I didn't mean to interrupt you, or maybe.
We're just finalizing the mediator with whom we will mediate the case.
When are you set?
The current trial date, you mean?
No, the mediation actually, is there a date?
It has not been scheduled yet.
Because your deadline's the 17th.
Yes, Your Honor, that's true.
Or the 16th? Is it still super busy getting mediation scheduled, or has that loosened up a little bit?
Well, yes and no. With the mediators that typically you use on these cases, it is busy. Mitch Moss has sometime, Chris Ancliffe is busy till June. The Judge Villa is very difficult to get in. Mitch is the only one that you can kind of get in at times, but he's kind of booked. So there's some thought to start using Carl Green. He's retired, but he has indicated that he would be willing to start doing some of the cases.
Oh, okay. Well, I mean, you all have a deadline. If you have, really good hopes that it'll resolve. Obviously, if you can't get it scheduled by the deadline, we still have until the docket call.
Let me ask you this question, just because I tend to always ask for continuances. Is this one that maybe we move back from May to June just so we have the additional month?
I think as long as we have the understanding that you all are scheduling. So if you can tell me by the final civil pretrial, if you haven't already mediated it, that you have a reasonable mediation date set, then I don't want to mess with moving the trial date. If it's likely you're going to settle, then you all, if it doesn't settle, we'll just have to take the next trial setting I can give you. If you're not
Thank you.
okay.
And
Judge,
Judge, on this case, the medical bills are only about $6,000. So I'm optimistic that the case should get resolved. I think it would be in the interest of both sides to try and get this resolved. And we'll work with Mr. Grambling to get it scheduled for the soonest possible date, and we'll communicate with the court.
Sounds good. We'll see you at the next setting. Thank you very much.
Thank you, Honor.
Have a good day. Who's next?
Same page, Your Honor, page 5. 2023 DCV 2183 versus Jose Ornelas and Raimundo Jimenez versus Cipriano Melendez. Can I have announcements, please?
Good morning, Judge. Cal Mandel for plaintiffs.
Good morning.
Morning. Nicolette Wilkerson for defendant.
Okay, we're just at scheduling status conference. Do you all need a trial date?
Yes,
I
ma'am.
think that would help, Judge.
Okay, let's get you a trial date. What's today? That's the question. Let's see, March 20th. So looking at March 2025, you want to do March 14th? March 14th, 2025.
That sounds good with me, Judge. I don't have anything in 2025 yet. Hopefully I'm still here. You never know.
Oh,
these
lucky
days.
you. Lucky you.
Yeah, that looks good for me too.
Okay, so your docket call will be on the 12th, about 30 days before final civil pretrial. Day before that is your mediation deadline. We'll get you the order. Please indicate your agreed mediator. Return it to the court, and you will not have to appear for the entry of that order hearing at 3 p.m. Okay?
Okay.
Thank you, Judge.
Thank you, Judge.
Thank you. Have a good day. Thank you for your patience.
Bye-bye.
Next.
Next one, same page, Judge. Calling cause number 2022 DCV 3519, Lluvia Bañuelos versus Luis Mendoza Flores. Can I have announcements, please?
Charles Sanders on behalf of the plaintiff, Lluvia Bañuelos.
Joshua Murphy on behalf of defendant, Your Honor.
Good morning, gentlemen. Final status conference. How are we doing on this one?
Well, as we speak, we have nailed down a deposition date for my client, and discoveries, I believe, has been complete unless anything else comes out at the depot. And I assume that we'll try to mediate the case, and if not, then we'll be trying it, as you know.
So your deadline, do you have mediation scheduled? Your deadline is the 16th of April.
Oh, actually, no, we don't. We don't have it scheduled. So
We don't, Judge. We'll work on getting it scheduled,
we'll work on getting it scheduled.
and we'll make sure if there is a continuance that needs to be filed, we'll file it prior to the next setting, Judge, but we'll work on trying to see if we can get it done prior.
Mr. Murphy, is there, if it ends up being that you file a continuance and that mediation is before the 15th of May, please indicate that information in there. I may hold off until we know what happens at mediation. Who's your mediator?
We don't know
On the agreed order, Judge, it's Judge Ancliffe, but we may come to agreement. I understand Judge Ancliffe is pretty busy and hard to get dates with. So we'll try to see what other mediators we can schedule with and get the ball moving in that regard.
All right, thank you very much. We'll see you at the next setting. Have a good day.
We're excused.
Thank you, Judge.
Yes, sir.
Thank you, Your Honor. Have a good day.
You too. Who's next? Mr. Bonatis, you're muted.
Sorry, Judge. I see on the same page, Mr. Nevarez Michael for the last case. I'm not sure, Mr. Porras, are you handling that one?
Yes, sir.
Okay.
Yes, sir.
Calling cause number 2022 DCV 3275. The Nevarez Law Firm PC versus Tires Auto Service LLC at all. Can I have announcements, please?
Michael Nevarez here for the plaintiffs.
Good morning, Your Honor. Tomas Porras Acosta on behalf of the defendants.
Good morning, gentlemen. Let's see, we have this scheduled for a motion for continuance. Is that it? And a final status conference. Mr. Porras Acosta, was your motion?
Yes, Your Honor. So, Your Honor, this is an opposed motion. Mr. Nevarez opposed the motion. We're asking for a continuance. Initially, Stephen Benzer was in our firm. He was the lead counsel attorney with myself and Mr. Casey Stevenson. Stephen Benzer left the firm. I'm now the lead counsel. This case is about Mr. Nevarez suing his former client for legal services, alleged legal services. And so ultimately, Mr. Nevarez did produce his initial disclosures. He produced about 30-something pages, but then now in his motion, he represents that he produced over 112 pages. But regardless, Your Honor, what we're asking is for, I had reached out to Mr. Nevarez in February, as well as I have called him in January to see if we can reset this case so that I can go ahead and get the ball rolling, taking it over from Stephen Benzer. Mr. Nevarez wouldn't answer, but at the same time, I finally got a contact with him, started sending him emails. I was asking him if he was okay with resetting, asking for a continuance. We went back and forth for pretty much almost a month. He asked me to even send him a docket control order with 90 days extension, as I asked. Followed up several times, and then ultimately he just says, I oppose. It's not that I wasn't diligent with it, Your Honor. I went ahead and now took over. I am the responsible attorney. Previously, I was doing sections of the case, but I wasn't on it, and that's no excuse. But it's not that I wasn't diligent with it. I simply asked for a 3-month continuance, Your Honor, for the docket control as well as a trial. Admittedly, I didn't provide an affidavit in my first motion, but we went ahead and amended our motion, and I did provide the affidavit. Nothing was changed on the motion, Your Honor, besides adding the words amended, as well as changing the date on the service. And so the other thing that I would like to point at the court, Your Honor, is we are part of the May 17, 2024 trial. But that's the position of ours, Your Honor.
All right, Mr. Nevarez.
Yes, Your Honor. I oppose the motion because I thought it was untimely. Mr. Porras Acosta has been on this case for 15 months, as has co-counsel Casey Stevenson, 15 months. They didn't do anything discovery, and they waited until the last minute. February 15th is when Mr. Porras first sent me an email. 5 days later, I responded to him asking him what do you want continued and for how long? 6 days later, on the 26th of February, I emailed Mr. Porras again and requested a copy of his proposed discovery plan. I didn't get a response. 2 days later, on February 28th, I again asked him to send me a copy of a proposed revised scheduling order, and then I finally got it on February 28th. Discovery ended 4 days later, 5 days later, on March 4th. They had 15 months to do discovery. They didn't do any discovery, Your Honor. And as I state in my response to Mr. Porras's motion, they should have long ago started discovery under the rules and Texas Supreme Court decisions. They should have provided me with whatever discovery they wanted at least a month before the end of the discovery deadline. So they're very untimely. The motion, as well as the amended motion that was filed, I think yesterday or this morning, I forget which, lacks the required affidavit of due diligence. They can't provide that because they didn't do any discovery in 15 months, Your Honor. This is a $6,000 case, Your Honor, and now they want to start depositions and discovery requests, and so I object. It's too late, too little, too late. They had 15 months, and then at the last minute they want to pursue discovery. That's contrary to the rules, specifically Rule 251, Your Honor, requires that any continuance be for cause. They haven't shown cause, Your Honor. They haven't even filed the required affidavit of due diligence. So I would submit that it would be improper to continue this matter. We have a trial date. As I've been noticing for the last half an hour, trial dates are difficult to come by. This is a $6,000 date. $6,000 case. I think we should just go forward. So I would request that Your Honor deny the continuance.
Okay, Mr. Porras, anything else?
Yes, ma'am. Thank you, Your Honor. And so, Your Honor, this is not, like Mr. Nevares says, it's not a very complicated case. Like I said, while he represented that he always produced 112 documents in initial disclosures, he didn't. So I went ahead and reviewed that. But what don't we have there is the actual client files. It's just the invoices. There's no client files. And so for me, this could be really easy if Mr. Nevares could at least say, you know what, okay, we've requested our client's files previously. He said no. And so he finally produces 112 pages of invoices, but doesn't produce anything else for the initial disclosures. For us, we could get it sped up, Your Honor, if Mr. Nevares is okay with providing me an extension, and we could be ready by May 17th. We just have to need to take his deposition, just send out some discovery for the entire file, which is the client's anyways, and we can be ready by May 17th, Your Honor.
Mr. Nevares?
Your Honor, the only thing at issue here is the invoices and the final statements for the 3 cases that I handled for Tires, the defendant.
With all due respect.
So, you know, if they wanted the client file, they should have asked for it 15 months ago. And now at this late moment, I see no reason why we should have to incur additional attorney's fees and costs when, you know, they failed to exercise due diligence for the last 15 months.
The motion for continuance is granted. The basis or part of the court's consideration, I'm not gonna say the basis, but part of the court's consideration is 2 things. The amount of time that defendant is requesting in terms of a reset, and also taking into consideration where you all fall on that trial date. That is a concern for the court because I believe realistically, Mr. Nevares, we aren't getting to your case on that date. And so because of that, I am going to refer this case to Judge Burrill. It's plain and simple. Order granting continuance, send it over, please circulate it, and then you will receive the referral order. That will hopefully ensure that you can get a quicker reset than I could give you. In other words, with that granted continuance, there is very little chance I could schedule you in 3 months or before January of 2025. So I don't want to do that. Hopefully, one of the referral Judge Burrell can set you sooner and give you maybe if you need an abbreviated set of deadlines for certain things. I don't know if that's still necessary or not, but get you scheduled much sooner. Okay. You can also set hearings, probably a little more flexibility in setting hearings. So that is the order of the court.
Thank you, Your Honor.
Thank you for your time. You may. Thank you, Mr.
Are we
Navarro.
excused, Honor?
You are.
Okay.
All right, ma'am, on the Google Pixel 6, what is your name?
Hi, Your Honor. My name is Lori Miller. I am with the Sayer Law Group, and I believe we have a hearing set at 11.
Well, it's 10:59. I thought I saw Mr. Dominguez here. What happened to him?
I don't. Oh,
Oh,
you
no,
asking?
sorry, ma'am. No.
I know a lot.
If you could tell me, that'd be great. I would appreciate it. But he was here.
He
I saw
logged
him
in,
log in.
Judge, and then he logged out. There he is. Ready, Judge?
Yep.
Calling cause number 2023 DCV 1994, Navy Federal Credit Union versus Enrique L. Dominguez. Can I have announcements, please?
This is Lori Miller. I'm here on behalf of the Sayer Law Group and for Navy Federal Credit Union.
Sir, Mr. Dominguez,
Yes, ma'am.
would you state your name for the record?
Yes, Enrique Dominguez.
And we were set for, I have us down for a status conference. I think we were pending a default hearing and maybe Mr. Dominguez has appeared in the past. We were set for default back in October. What's the status on this case?
Your Honor, I haven't spoken with Mr. Dominguez directly, but looking at my notes in our firm's file, it sounds like, it looks like to me, we are on the verge of finalizing a settlement with him. He can speak to whether that's true or not, but that's what my understanding is. So I would just, I'm sorry.
I'm sorry, Ms. Miller, I didn't mean to cut you off, but Mr. Dominguez, is that true? Are you all working on a settlement on this case?
Yes, ma'am. I'm not sure I spoke with who I spoke with, but I couldn't get connected to Lori. I think they're waiting on Navy Federal for the agreement.
Okay.
Details are, I don't know if you need them, 302.
No, Mr. Dominguez, let me ask you this. What was the last contact you had with plaintiff in terms of working that out?
Yesterday.
Oh, okay. So we have been we were at status. I'm fine to give another 30 days to see if we really are at last stages and maybe this goes away or if we need to take another course of action. Are you all okay with 30 days or do you want more time than that?
I think 30 days would be appropriate. That's what I was going to ask for.
Okay. Mr. Dominguez?
Yes, Your Honor.
We'll do a 30-day reset, log on the same, everything's the same, the Zoom login, and we'll do it at 11 o'clock. If something gets resolved, I'll expect paperwork and that way you don't have to come to the hearing. But if not, we'll see you in 30 days, okay?
All right. Thank you, Your Honor.
Thank you for your time. You may. Thank you, Mr. Dominguez.
Have a good one.
Is that everybody?
That is all we have, Judge.
Okay, thank you. Thank you, Erica.